I'm an intellectual property attorney and I'm a software developer. And listening to one of my favorite software podcasts, the Shoptalk Show, they had a copyright question. So here's their question and my answer. Hopefully I can help clear a few things up.
We'll see if we can hone in on an actual lawyerly answer through time and publishing. So number one is Anand's employer wants to put a copyright notice at the top of every single source file in their entire repo. And that's what just they think is the right thing to do. And Anand says, this feels wildly excessive to me. Is there any world in which this is necessary, or does the license in the repo cover this?
So there are a few concepts here that we need to disentangle, specifically the copyright registration, the copyright notice, and the license. Okay, so first let's start with the basics. What is a copyright? It's any original work of human expression fixed in a tangible medium. When that happens, you have a copyright. It is automatic. For instance, I created notes for this video. These notes are an original work of human expression, and the computer's memory is considered a tangible medium. Therefore, they're copyrighted. I made a recording of this video. We can argue about how creative and how original it is, but it's original and creative enough to be copyrighted the second it hits the SD card. If you want to go further down this legal rabbit hole as to what's creative, let me know and we'll do it. For instance, one of the seminal law school cases covering creativity is the phone book. Is the phone book copyrightable? All right, so that's a copyright. It happens automatically. So now you're probably wondering, well, if it happens automatically, why is there such a thing as registration? How does that actually work? And the problem is there's three legal regimes that get confused: copyrights, patents, and trademarks. They make up the general IP umbrella. Some of those, like patents, really require a registration to be enforceable at all. Other ones, like trademarks, vary, and copyright doesn't need one at all. There are two reasons, though, why you'd want to file for a copyright registration. The first reason to register your copyright is you're going to sue for infringement. The law makes copyright registration a pretext to suing, but the registration can come after the infringement. And the second is for statutory damages. If you register your copyright before the infringement or within 3 months of its creation, you can be entitled to statutory damages. In a non-statutory case, the copyright holder needs to show that they either lost real monetary profits from the infringement or the infringer profited. With statutory damages, the copyright holder can somewhat end-run the damages requirement. That's how in the Napster days, the recording groups could sue song pirates for downloading an MP3 for $150,000. They registered the sound recording with the Copyright Office, and then they sued, claiming willful statutory infringement. Willful infringement gets to the heart of this question, the copyright notice. Until the late 80s, U.S. law required a copyright notice. But in 1989, the U.S. signed the Berne Convention that removed the need for any mark. From that convention, most of the world is standardized on copyright law. So in 2024, the only thing a copyright notice can legally do is help negate an innocent infringer defense to damages. And that's somewhat superfluous. Most people know when they're intentionally copying. However, I still use them in my own work as a practical matter because people think that they mean something, and it may give somebody half a second to pause. So to that end, they may be useful. So staying true to my attorney roots, I had to give you the full answer. But to cut to the chase and finally get to it, the notice on the top is ridiculous. There's no world where you need to put it everywhere like the question's asking. And then here's the second related question. From what we discussed, you're already going to know the answer, but I'll let this one play for a little bit because I think Chris and Dave raise a few other interesting issues.
Here's another one that's the follow-up question is that copyright in the footer of a website. I guess it doesn't have to be in the footer, but I guess probably there's some design precedence that puts it there, and or it just has to be at the end of content, which I wouldn't be surprised. You see it pretty commonly. Well, I assume that's why Anand is asking this question. Does it matter?
I mean,
no. Here's this other thing that you hear
LLM,
about it.
It doesn't matter.
Well, god dang right it doesn't. You hear that like the technology just doesn't even really exist to untrain a model. Like if you opt out, a company can be like, okay, cool. Future trainings won't include that, but we cannot, because the technology doesn't really exist, pull your stuff out of the model that's already been trained.
Whoops.
Wow, that blows my mind.
Yeah.
Anyway, what if it did say 2023 down there? Would that open them up to problems? Like you could, steal all their 2024 content because it said 2023. Seems highly unlikely to me. Usually what you hear about this is that those don't matter at all, that there's an implied copyright on it.
So now you know that the notice may help mitigate an innocent infringer damage defense. And by the way, that defense just means that you pay less, not that you're off the hook, you'll still owe something. Other than that, it really has no legal effect. And there's no implied copyright. It's copyrighted the second the pen hits proverbial paper. So what about large language model training? It's being litigated now, but based on prior case law, lifting web material is copyright infringement. There were cases in the 90s that held the simple act of copying code from your hard drive into RAM implicated copyright laws. The litigation will focus on fair use, which is its own bag of mystery. If anyone's curious or has specific questions, let me know, and I'm happy to get into that or any other IP law questions. And I may pop off about the WP Engine WordPress craziness, so stay tuned. So huge thanks to Chris and Dave over at the Shoptalk Show for asking the question and for doing the podcast. I've learned a ton over the years. And if you guys have any other questions, please send them over. We'll do another video and hopefully help everybody out.